Can everyone hear me well? As it is now 2 o'clock, we will begin the conference shortly, so I would like to ask everyone to enter the hall. Good afternoon. Welcome to 2024 KIIP Alai Literary and Artistic Works Copyright Conference. I would like to thank everyone for being here. We have Part 1 and Part 2. I will be the host for Part 1. I am Park Yoon-seok from KIIP. In fact, today's conference is related to literary and artistic works, for which KIIP is conducting a government support project. We are conducting a 3-year R&D project. It started in 2023, and this year is year 2. And we will finish up the project next year. And broadcasting monitoring system for literary and artistic works will be implemented for the first time, and that is the core of the project. Since we are in year 2 now, in order to spread the achievements of the project, policy issues have been combined and they are to be discussed in conferences, and that is the background of why we are holding this conference today. With respect to today's conference, KIIP is together holding it with Alai, which is based in France, and there are 35 national offices of the association. So we are jointly hosting today's event with Alai Korea. So members of Alai overseas are also joining us on YouTube live stream. The live stream is only in English. So all our audience and virtual participants in Korea will have to listen to the event in English, but later on we will upload a Korean version of today's event. Without ado, we will begin the 2024 KIIP Alai Literary and Artistic Works Copyright Conference. We will begin with the welcoming remarks. President Son Sung-woo of KIIP was not able to attend, so Director Lee Gang-young of Planning and Management will read the script instead. Please welcome him with a warm round of applause.
Distinguished guests, ladies and gentlemen, I would like to particularly thank Professor Kyung-soo Kim, President of Alai Korea, and all the partners of the KIIP. Thank you very much. These days, we are living in a very abruptly changing environment. The copyright regime to facilitate the use of literary and artistic works in a digitalized and broadcast environment has a big role to play. And we are here to discuss this very important issue. I'm very happy to be able to hold this conference, and I'd like to thank everyone for being here with us today. Copyright is not just a tool, a legal tool to protect rights holders. In fact, creators are able to be provided with an equitable remuneration for their creative effort, and at the same time, societal-wise, it's a very important aspect in sharing of the knowledge and culture. So in 1710, the Statute of Anne was legislated, and since then, the copyright regime had played the role of striking the balance between creators and consumers and has continuously developed. Everything under the sun nowadays is copyrightable, and in this sense, copyright will evolve in some way or another under digitalization and also AI. So it's a very timely situation that we are discussing this important issue. And so this digitalized broadcasting environment and the abrupt changes is providing new opportunities, but at the same time creating new challenges. For example, Netflix and other kind of streaming platforms show very well how we can harmonize the distribution and usage all around the world for digital contents through copyright regimes. Also, YouTube is necessitating the clarification of the border between the fair use and also copyright infringement in a user-generated content platform. So in today's conference, I think we'll be able to discuss how this kind of copyright can evolve under a digitalized environment, and also how we can further facilitate the use and the creation of literary and artistic works. So I'm looking forward to some in-depth discussion on these issues. The copyright regime has to be able to provide benefits both to the creators and consumers, and in order to be able to forge a fair and sustainable cultural ecosystem, we are hoping that we'll be able to share some good insights and wisdom at this conference. Thank you very much.
Thank you very much for your welcoming remarks. We will now hear remarks from President of Alai Korea that heavily contributed to today's event. Let's welcome President Kim Kyung-suk of Alai Korea with a warm hand.
안녕하세요.
Hello, I am Kyung-suk Kim, professor of Sangmyeong University and also president of Alai Korea. I'm very happy and honored to be co-hosting the 2024 Literature and Arts Copyright Conference together with the KIIP and COLAA. Today's event will be a great occasion to discuss some of the most pressing issues regarding copyright of literary and artistic works, and to strengthen the bond within the IP community and outside of Korea. So thank you to the president of the KIIP and also to the KOLAA for this invaluable opportunity to co-organize this very meaningful event. And I would also like to thank Professor Gotson for delivering a congratulatory remark through a video just after mine. He has sent the video all the way from Belgium and taking time out of your busy schedule. Alai Korea was launched in 2016 as the Korean branch of Alai, and we have continuously been researching copyright ever since. And thanks to these activities, and as President Gotson is going to mention in his video remark, the 2028 Alai Congress will be held in Korea. And I believe that the important event will contribute to Korea playing a very important role, and for the Korean copyright regime to further develop. So we are here with various different experts, and we'll be able to share with the Korean participants as well as participants from overseas some of the activities that we have been doing here in Korea. And also the three presentations will contribute to searching a way forward regarding the issue of copyright regime to facilitate the use of literary and artistic works in digital and broadcasting environments. Last but not least, my sincere gratitude goes to all those who worked hard to organize today's event, and the experts who will moderate, present, and speak as panel discussants, as well as all the participants who are here with us today. Thank you very much.
Thank you, Professor Kim, for the congratulatory remarks. Next, since Alai is headquartered in France, the inaugural president of Alai was none other than Victor Hugo. And In 1800s, when Berne Convention was established, Alai played a big role. So the president of Alai, Professor Frank Godson, sent us a recorded version of his congratulatory remarks, which we will watch now.
Hello to everybody in the beautiful country of Korea. My name is Frank Godson and I'm the president of Alai. Alai is an international association that promotes the moral and economic rights of creators, in line not only with the Convention of Berne, but also of the Universal Declaration of Human Rights. Alai represents more than 2,500 members, distributed over 35 countries in all continents. We, as an international association, we strongly encourage national Alai groups to organize and foster national meetings and congresses in their own country with a view to develop legal protection systems for authors and creators. Therefore, we welcome very much your initiative of today to have a joint conference between the Korea Institute of Intellectual Property and Alai Korea. The topics you are going to tackle include the protection of literary works in the digital environment and the establishment of fair remuneration systems. These are indeed topics of utmost importance in today's world. On the level of Alai International, we had the occasion to adopt already a resolution voted in our executive committee in February 2024 concerning the impact of artificial intelligence on copyright. In that resolution, we considered that in the context of AI, the right holder's authorization must be obtained, and that at least fair and equitable remuneration should be guaranteed for feeding AI systems with existing works or performances if you use them as training data. In the same resolution, Alai also affirmed that there is a humanist principle that inspires the provisions of the Berne Convention. It requires us to consider that outputs resulting from purely mechanical processing are not intellectual creations. Output can, according to the Convention of Berne, only be protected if there is proof of creative and determinative intervention by a human being. Finally, Alai also affirmed that the use of an AI system must be accompanied by a duty of transparency. Upstream transparency first, for the information of right holders, because they have to know whether pre-existing protected works or performances have been entered into the AI system for training purposes. Downstream transparency also, after the production, so that potential buyers or users of the generated output are informed of its production process. I wish to congratulate KIP and Alai Korea with your excellent initiative to further take up the study of all the intricate problems related to this subject. And I wish you every success with your event. Finally, I would like to express my satisfaction that the Executive Committee of Alai, in its meeting of Paris in February 2024, decided to grant the organization of the Alai 2028 Congress to Korea.
예, 고tzen 회장님께서
As President Kotzen mentioned, in 2028, the Copyright Ally Forum or Congress will take place. As he mentioned, in today's broadcasting digital environment, fair remuneration for right holders and fair remuneration for AI training data are key issues. So, through today's conference, we will look at the remuneration for educational use of works and AI training data through our in-depth discussions. We will have to move on to the presentations, but before we must have a photo opportunity. So I would like to ask all participants in the hall to come up to the stage for a group photo.
그러면 이제 발표를 위해서 잠깐
So we are just going to rearrange the stage before we go into the presentations. Please bear with us for a moment. Thank you.
오늘 1세션은
So session number 1 is about educational contents, especially focusing on literary and artistic works and fair remuneration. I'm going to ask Professor Ji Young Han of Chosun University to moderate, and the presentation will be made by Professor Jinwon Choi of Daegu University.
안녕하세요.
Good afternoon, everyone. Very good to see you all. So, I am Ji Young Han. I'm a professor of Chosun University. I'll be moderating the session number 1. A bigger round of applause, please. Thank you. So today we're going to be talking about educational content and equitable remuneration. And the presentation is titled Educational Content, the Use of Copyrighted Works and Equitable Remuneration. So Professor Jinwon Choi is very active in the copyright field in Korea. He's not that old, but I really respect him. He is Jinwon Choi, professor of Daegu University. And as designated discussants, we have Professor Il-ho Lee of Yonsei University. And the second panelist is Professor In-soo Kim from HOOFS. So I read the presentations and the panel discussions, and that led me to a few ideas. So when I perform lectures at university, I am quite surprised when I see my lecture videos on internet, and sometimes I see somebody else selling my lecture for a fee. And so these kind of university lectures are being distributed and circulated on the internet without my permission. And today, we're going to be talking about educational content and fair and equitable remuneration. When we talk about education, it has a very strong public character. And copyright, on the other hand, is a private right, it's a property. And so there might be some issues regarding the compatibility between the two sides. To what extent are we going to allow education sector to be seen as a public commons? And nowadays, you have the tertiary education, but you also have primary and the secondary education, and the remuneration between the two sides show quite a big gap. And so for the lower level schools, the public characters seem to be more higher, and so the remuneration level is much lower than that of the universities. So up until now, the focus had been the use of copyrighted works in education and contentions regarding the use. But today, here, we're going to be talking not so much about the property side, but the right to claim remuneration and its relationship with the exploitation of the works. So without further ado, I'm going to now give the microphone to our presenter.
네, 방금 소개받은
Hello, my name is Junon Choi from Daegu University. As was just introduced, I have about 20 minutes to my presentation. So anyway, a little while ago, I read a book, and it's a really popular book. It's called India is Broken, and it's about why India is not as developing as people had expected it to be. And that's because of the failure of education, according to that book. In Korea, people talk about the exorbitant private education fees, and the Ministry of Education says that vis-a-vis the GDP, Koreans pay 2 or 3% of that for private tuition, which is something like 5 times more than the average of the OECD countries. It is a big problem. But General MacArthur had once said that Korea will take about 100 years to develop, but it used to receive aid, but now it became a donor in a very short period of time. And I believe that the rapid development of the country was based on people's really passion and commitment to education. And as Professor Han had just mentioned, educational contents have to be protected and has to be able to respect copyright, but also we can't let that become a barrier. So I have a few graphs in my first slide. People say that the publishing industry is going through a very turbulent time. So you see the blue line going downwards. This is from the Ministry of Culture's report regarding people's reading habits. But then the yellow and the red are marked in demarks the students. So that's not decreasing. About 60% of the publishing industry accounts for education-related materials. So in Korea, the educational material and the publication of such kind of material takes up a huge proportion of the industry. And so I'm going to focus on that particular part, the educational content. So there was a German scholar who came to our university and asked the question, how many high school students go to university? And then he said, 18%. So no, I said 80%. And then he kept on saying 18, you mean 18, not 80, right? And so for him, the fact that 80% of the high school graduates go to university was just something that was not understandable. And in Gyeongbuk province, about 89% of the high school graduates go on to university. So a very high rate. But it's also a very highly competitive edge for Korea as well. In the past, you may think copyright cannot be guaranteed within the educational field, but that kind of perception has changed nowadays. And so that's why in the past you had people, illegally photocopying textbooks nearby universities. And so you probably saw these posters warning against this kind of illegal reproduction and copying of textbooks. But nowadays you don't really see this kind of practice. On one hand, there's the digital scanning of books, maybe, but you don't really see the physical photocopying. And these days, you may also witness the textbooks being distributed in the PDF form or being scanned and digitally circulated. So these PDF versions of the textbooks are being sold on the internet, and this is an illegal infringement of copyright. So if you go to second-hand internet platforms on the internet, you'll be able to see this kind of books being sold for the PDF. You can see that the price is 16,000, but in fact the actual book is something like 20,000 Korean won. Remember in the past, we would pay just 100 Korean won to watch a movie on cyberlockers. And we thought that 100 Korean won was costly. But here you see that the price of the PDF file and the price of the actual book is not that different, but nonetheless people are opting to buy a PDF form because it's a lot more convenient than physically buying the book. So, some service providers are thinking of setting up a platform to provide the digitalized version of university textbooks. But for now, because these university textbooks are not provided in the form of an e-book, many students are opting to illegally scan the textbooks. So you see, if you look on the YouTube, you see all these video contents that teach the students on how to download a certain app to scan the textbooks in 10 minutes. People take photos, use the apps through their mobile phones, and even if you take a bad photograph of the pages, the apps will do a great job of making a very good ebook file. So we need to think about these circumstances. Actually, this topic has come up for discussion in many different venues. And so that's why people are thinking of adopting the system of private copying remuneration. So nowadays, you don't really have the physical photocopier that much. So that's why, in that regard, private copying remuneration is emerging once again as an important topic. So there was one time where digitalized textbooks was a big issue in society. But nowadays, people are talking about AI digital textbooks. Nothing has really changed. But what has changed is that AI will train school textbooks and will then create contents that matches the level of the students. So it's slightly different from the concept of the generative AI. And so relevant laws have also been revised to allow for this kind of training. So, but then, is this kind of training of AI for educational purposes compatible with the current form of the Copyright Act? It's something that we need to think about. So I think some of the other speakers will touch upon this in greater detail. So first of all, now let me go on to the issue of the fair use doctrine and education. So, people used to say that people who steal books are not really thieves because they steal books to learn, and we don't really reprimand them for breaking copyright rules. And so education is very important, but at the same time, the copyright is very important. So we have to balance the interest between the two sides. If you look at the Statute of Anne, it says for the encouragement of learning. And if you look at the Berne Convention, and also if you look at the EU's directive on copyright, there's always the provision saying that it's for the benefit of learning, for promote learning. So this always has to be taken into account. And if you look at the laws of other countries, it would also quite similar, whether it be Switzerland or Germany or many other countries. There are provisions that allow for the use of works for educational purposes. And you have the ECL in Northern Europe. Also in Korea, there are many provisions to allow limitations and exceptions for education, mainly Article 25. But then there are other provisions as well. So we have in the Copyright Act, Article 13, Article 25, Article 28, Article 35, KAIST, regarding fair use of works. And there's also Article 94 and 103 on TRES, and also Article 104 on the prohibition of circumventing technological protection measures. And so in education, there are many exceptions and limitations to copyright. But there was one particular precedent that is garnering a lot of interest. And so the Korea Institute of Curriculum and Evaluation had actually used a certain literature as an examination question, but then the Supreme Court of Korea says that the Korea Institute for Curriculum and Evaluation must pay 10 million Korean won as compensation. And also there are qualification exams. So qualification exams are a very important system educationally because it allows for people to receive degrees and graduate without attending the school. And so the qualification exam questions are also disclosed from the previous years so that people can prepare. So then does that mean that this kind of disclosure of qualification exam is also illegal? So, but then it's not just the qualification exam questions. For the middle school and high school questions, whether it be through the website of the Provincial Education Office of Seoul, these exam questions have already been disclosed. So what are we going to do about the qualification exam questions? There was another judicial precedent in Korea of using songs and other kind of literature works. And there was another issue when somebody had recited a very short poem, but then the author of the poem said that it was a violation of copyright and that remuneration had been paid. And in television dramas, sometimes the some songs or some works of literature may be recited or sung. And sometimes because of those recitations, the works can become hugely popular. But then the rights holders have started to ask for remuneration. And that begs the question, where do we draw the line between what is fair use and what is not fair use? And I think the third presentation is going to be talking about the quantifiable criteria. But anyway, let me go a little bit more into Article 25. And it is a very strong limitation. But the private sector education or private academies could be or not could be included in the scope of Article 25. So in Japan, you do have to notify, but in Korea, you don't have to have notification. You just have to pay a remuneration. And it's about 10% compared to the tariff imposed by the collective societies. About 10 years ago, I read a report about the Japanese system, and it does depend on the educational system, but if you print about 10,000 copies of elementary school textbooks, in Korea, the remuneration rate would be only about 1/10 of what is being paid in Japan. But of course, the circumstances were quite different when the state had actually written the textbooks themselves. Nowadays, we don't really have the state-authored textbooks anymore. It's mostly state-approved textbooks. Textbooks are also made by publishing houses, and it's a for-profit industry. So under these circumstances, what are we going to do about the remuneration level? There are also use of works as supportive educational material, and for these supportive educational material, remuneration also has to be paid when works are being used in those material. And if you look at the guideline regarding the remuneration, it's between 1% and 10%. And that allows for certain works to be used. Before, in fact, even this 1 to 10% of remuneration was not paid, and thus the works were not allowed to be used. But nonetheless, professors used those works thinking it would be covered by the provision of fair use. So now universities do pay a remuneration, but nothing has really changed from the university's perspective. We pay a remuneration, but the scope of what we can use has not become more broad. And so many professors and lecturers are still using more than they're supposed to be using, which could run into issues of infringement of copyright. So anyway, about 10 years ago, this kind of remuneration for supportive material was also adopted. And also another question that I have about this remuneration system is that for schools of high school and under, the schools don't have to pay remuneration for material that is used for educational purposes. I'm not sure why the cut line is a high school or not, but I think maybe if the local governments make a request that they're willing to pay a little bit more for remuneration if they're allowed to use a little bit more of the works, then I think it will be beneficial for all, and the municipal governments indeed did make that kind of request. But the response was negative. So, teachers and professors are using these works, but some people have said that they don't want to get the professors and teachers to pay a remuneration when they are using a work for educational purposes. And I said, why not? I also work in a university. I am willing to pay remuneration.
이런 얘기를 했죠. 그 잘 이해가 안 가는데.
So there was this whole debate when the system was being adopted around the remuneration for education material, but then there's also remuneration for supportive material. So what do you exactly mean by supportive material? Nobody really knows, and this system only exists in Korea. Many other countries have this kind of remuneration for education material, but when it comes to supportive material, it's quite unique to Korea. For example, the teachers during the summer holiday and the winter holiday go on training sessions. The material that is used by the teachers during the holidays for their own training are categorized as supportive material. That's fine, but then how do you draw the line between the supportive material and the educational material that are both used in class? And like I said, the borderline is a high school, so schools under or schools that are high school and below are not obliged to pay a remuneration. So I think in the past, this kind of supportive material remuneration was adopted because for the lower level schools, the municipalities had to pay if they categorize the material as supportive material, but not if they categorize it as an educational material. So I think maybe that's why this category had come into play. But I believe that this Article 25 has to be overhauled because it's very confusing and it's not very clear.
그래서 근데 수성국적 고등 같은 경우에도 과거에 학교였다가 유아교육법에
And also the scope of who has to pay that kind of remuneration for the educational or educational supportive material have also broadened. Before it was just until elementary school, but nowadays kindergartens are now included, and also different types of education and training schools have also been included into the scope.
제가 생각할 때는 이것은
That's because we now have school credits, the Act on Recognition of School Credits. So a variety of different education and training systems are also categorized as institutions that have to pay the remuneration. There are also a lot of remote teaching institutions. And that also brings us to the question of what we are going to do about the qualification exam cram schools and other kinds of cram schools. In Korea, there are many cram schools that are very unique to the Korean system. So how far are we willing to expand the scope of the remuneration? So I'm a little bit concerned that there are still so many questions and challenges that we have to overcome regarding this remuneration for educational materials. So Korea has become an IP powerhouse, and it seems that the culture and arts, the market and exports has increased greatly. There's a huge trade surplus in both the IP and cultural fields. And many people have said that, Hallyu is really empowering Korea. And statistically, Korea does earn a lot of money from copyright-related industries. And so, I think taking those circumstances into consideration, the ministry and the related government agencies will probably start focusing more on protection side of copyright. Anyway, how are we going to draw the line regarding the remuneration is not an easy issue. So it's still being researched regarding the remuneration for educational material. And surveying the situation is not very easy because it's very difficult to draw the clear line of what schools or who should be paying the remuneration and who don't have to pay remuneration.
제가 생각할 때는 그 그림의 대부분, 뭐냐면 PPT 화면이기 때문에 그림이 들어가 있는 건데 그 그림의 대부분
There was this one PDF I was looking at. It's hundreds of pages long, and there are hundreds of images in it. And for me, I thought that could be covered by fair use. But then the remuneration is not pay-as-you-go system in Korea. It's a total amount system. So, of course, the universities can opt for pay-as-you-go system to pay for the remuneration, but they don't usually choose that kind of methodology.
교육부나 문화부 이름 내기가 불편하니까 협의회라고 해가지고 발표했던 가이드라인입니다. 거기에서
And so, in the existing guideline regarding the remuneration for educational material, like I said, it's from 1 to 10%. And elementary, middle, and high schools don't have to pay a remuneration, which means that they don't have a guideline either. Does that mean that textbooks can use 10% or more? What happens in that case? And if you look at the guideline that came out during COVID, there is one provision that says that you can use all sorts of works for textbooks.
이렇게 잘못 오해, 제가 볼 땐 오해인데요. 그런 것들에 대해서 아직까지
Which led to a lot of misinterpretation about that provision, about the amount of works that can be used for educational purposes during COVID. And then in 2013, the Ministry of Culture also came up with a guideline regarding use of works for educational purposes. So that guideline said that if you make a photocopy of the work and distribute it to the students, it's not a matter for enumeration. It's only a matter for prior approval. But then that also led to a lot of misinterpretation, and that also leads to a huge amount of problems. So there are so many different issues we have to take into account when we are reviewing this issue of remuneration. Here are some examples of laws in other countries. So, for example, in UK, no more than 5% of a work can be copied in a 12-month period for educational purposes. And there's also the case in the German law, Article 60 says it's about 15%. The remuneration actually on the average is something like 1,200 Korean won per year. It's quite low in Korea. So many people on the ground, the practitioners, say that we have to forge a market. There was one researcher who said that he just can't teach in the university because of copyright. What kind of works is he allowed to use, he asked. And I said, you can use anything as long as you pay. Or if you get permission, you can use anything you like. So the AI working group also came up with a guideline which says that if there is a certain risk, just get permission. Yes, that's the correct answer indeed. But the problem in the education market is that there is not that much of a licensing market in the first place because of the transactional costs. And the CLA in UK has a blanket license that makes it a lot easier for contracts and licensing contracts to be signed. Of course, copyright cannot become a barrier in education. And I think sufficient and adequate remuneration has to be paid, but at the same time we have to ensure that education is no way hindered by this kind of copyright. Thank you very much.
좋은 발표해 주신
Let's once again thank Professor Choi for his wonderful presentation. As I was listening to his presentation, the law of copyright and the policies for copyright are two different approaches that must be harmonized. And this has been something we've always much thought about. So when we think about fair use, we have provisions under our Copyright Act where there are different provisions for commercial and non-commercial uses, and some cases are
And so sometimes remuneration rights are recognized in some areas and some not. And so I think it gave us a lot of food for thought in that sense. So I'm going to now give the mic to Professor Il-ho Lee from Yonsei University.
네, 안녕하세요. 방금 소개받은 이일호.
Good afternoon. I am Il-ho Lee. Your presentation was very insightful. You provided a lot of insight from various perspectives. I have 3 bullet points for my discussion, which I will make brief. First of all, when it comes to Article 25, it has to be reformed. And I have 6 points that I would like to raise. To mention some of them, as we've seen from the slide, the industry of edutainment is seeing huge growth. Nevertheless, since it is under the education sector, we see it as a rather pure industry. And all the state or public educational agencies, even including the credit bank system, have a rather industrial approach to education when it comes to the state agencies or municipalities. Even if they run educational institutions, rather than developing their own educational programs, they outsource development to acquire content for education. When it comes to the credit bank system, they mostly use made content that they acquire from other companies. Of course, we must support the education industry, but whether it is the point of the Copyright Act to do so is questionable. Since credit back system is relatively new, it still has a long way to go, but some adjustments would have to be made when applying the provision to the system. Second, uncertainties must be resolved as we approach these issues. The second and third points will be covered right now. How far can the remuneration system cover is something that needs clarification. When it comes to workbooks, workbooks are often edited and distributed by the teachers, but simply because the institution is a school, does that exempt them from the duty for paying remuneration? And when it comes to content in the educational industry, the industry receives much incentives at this point, but when that provision is applied to even content that is not purely educational, then it might be rendered meaningless. And if we look at the guideline, the remuneration applies from once the portion exceeds 10% of the total work. But that means we can't use one academic research paper at a time. But if a book, no matter how long it is used as long as the portion does not exceed 10% of it, then it is exempted. So would this be reasonable? That is a question that I have. And I added an image here, which is a question I asked and got a response for. The existing license agreements and their relationship to the remuneration system has to be further clarified. At the working level, some compromises are being made, but there is no legal provision to support that. So if there is a license, then could we get a discount on the remuneration, or are they two separate, completely separate areas? Are some issues to be further clarified? And this is the last point I would like to raise under this chunk of the topic. We need clearer concept of the right holder who has the right to claim remuneration. So here we are seeing that the right holder may be different from the author. So do those who have been transferred the right to claim remuneration do so? So which rights do they have to be transferred to make them eligible for remuneration? Does the entire property rights have to be transferred to be able to claim remuneration, or does partial transfer work? These are issues to be ironed out in law. And please read my paper regarding the TPM issue. And moving on to the exception or limitation provision, we have two approaches for the remuneration. One is under the limitation provision, and the other appears for the remuneration provision for authors and performers, which says that equitable remuneration should be paid. But if we look at the provision under the exception provision, it does not have such mention. So three potential approaches are possible. Sometimes there could be the presumption that free use is based on the idea of free of charge or free of remuneration duties. Or the second approach could be that the limitation or exception provision merely exempts the need to acquire individual permissions, so remuneration is something different. And third is somewhere in the middle, where the amount and nature of remuneration has to be determined due to the intention of the remuneration. And my last part of the discussion is about scanned files. So the publishers are raising issues about scanned files. So this is where talks about remuneration for private copying is raised. And the same goes for the educational purpose use and its remuneration. Publishers are hardly seen as beneficiaries here. And I haven't been able to see the determination for a suit that was deliberating this issue, which I believe is still ongoing. When it comes to the scanned file issue, the publisher and the rights holders should think about some points. I'm sure we've all had experiences of buying ebooks. They are quite uncomfortable, in fact, because the ebooks that we've purchased from different platforms can only be read on specific platforms. We can underline them, but we can't print them, or most of the features are very limited and they all have different UIs. Students, I'm sure, have enjoyed the convenience of ebooks or scan files instead of ebooks. So I don't think ebooks will be able to replace scan files, which are much more convenient for our students. So when we look at the market of academic publishers, I think this is a point to be considered. I've really summed up my discussion. So to my points, if Professor Choi has any thoughts, then I would love to hear them. Thank you.
말씀하셨지만 실제로
So you have three questions. So improvement measures for Article 25, and the second nature of remuneration, and third is the question about scanned files. I think we could hear the other discussion out first and then hear from Professor Choi on those points. So now the mic is to Professor Kim.
Thank you very much for your presentation. So I'd just like to point out two things. So there are some things that I wanted to ask, but it overlaps with Professor Lee's question, so I'll just ask some other questions. So the first pertains to the remuneration paid by education facilities that my university is also paying as well. So if we have a private copy levy, then people will have to pay doubly, because universities is already paying remuneration, but then they will also be paying the private copy levy when they buy a device. In HOOFs, you have AI Institute, and there are many industry collaboration projects, and we also teach our engineering students to make startups. But then if we don't have the data, we can't do anything, because we're working with AI modeling or developing AI models. So without data, the students are not able to go about doing their course. I know that there are some bills with the TDM exception, and if the TDM exception is passed in Korea, how are you going to go about remuneration for the TDM exception? So I would like for you to perhaps touch upon that. But so for the first question, I think you can just refer to the conference proceedings. So anyway, there are academia industry collaboration projects in my university, and we use mostly actually the Kaggle is a platform. And so people who own the data would share and disclose all of their data. And with the database, they propose a problem that they want to see solved. So we have the Kagglers, members of that community, which can be students, or it could be data scientists, or it could also be industry practitioners, and also people who are working to become data scientists. Anyway, so anyone can use data freely on Kaggle. And when we are doing this kind of industry and academia collaboration projects, sometimes the companies may even provide the data that is confidential. Or maybe it's not just a matter of confidentiality, but maybe it's a matter of copyright that they have to be careful of. And so when students use this kind of data set, they have to sign an NDA and be careful of these possible violation of rights whilst using their data sets. So these kind of courses are part of the official course for the degree. And it's all connected also to their graduation theses. So these projects are very important. And then there are also hackathons in my university. So if students are participating in a hackathon, and say 100 or 200 students are participating in the hackathon, and they have to develop an AI model using the data that is given, because there are huge amounts of students, there's a huge amount of data that is being used. And in this circumstance, the school itself would actually offer a bid and also then get a license to be able to use a data set. And so the university would go through all these processes to organize a hackathon. And so in that sense, we believe that permission has been attained, or license has been attained. But then if the TDM exception is adopted and remuneration scheme is introduced, then I think the circumstances will become completely different on the ground. In university, the remuneration that is being paid by HOOFs is in a total amount system. And in the case of data, I think maybe pay-as-you-go system can also be introduced. But I am not really sure about the efficacy of this kind of pay-as-you-go system. So these are the two comments and also questions I would like to ask Professor Choi, because I know you're quite knowledgeable about these issues. So I'd like to hear from you what you think. Thank you very much. So we have two questions. One is about the school remuneration and the redundancy it may have with the private copying levy. And the second is about the TDM exceptions and remuneration and how that would work hand in hand with the use of the data sets for AI model development. So Professor Choi, would you like to respond to those questions? So thank you very much for those questions.
이희로 교수님 말씀 주신 질문.
First, I will respond to questions from Professor Lee. This may not be the absolutely correct answers, but the biggest issue about Article 25 is that we need to restructure the whole provision. If you look at actual classrooms in schools, there is no distinction between the use of textbooks and the use of copyrighted works, and the remuneration is rather outdated. If we look at the reality, so we are seeing court cases, we're trying to distinguish the purpose of the use of works, whether it's for classes or not, and the whole article should be revamped. And the second point, the Article 22.2 is often mentioned in the papers. In Korea, if you see the background of the remuneration system, the users always made suggestions based on the market price, and it was mentioned in the precedent in Korea and in Germany also. So we don't necessarily have to go back to the stage where we're paying remuneration in a symbolic way. I think paying more remuneration to more actively used works, it would be more helpful for the educational industry, because now at this point, even if we pay, there is not much work that can be actually practically used from my experience. So either allow users to pay more and use more, or just, I think they might as well just not pay at all. So I think we should look at ways to make the remuneration equitable. And I think the private copying issue is something I have to be cautious about, but levying remuneration for scanned files is, well, I think we have to look at the market. And in the past, MP3s were made and used, but now we've moved to a streaming system, and many people in their 40s and 50s really don't like to pay first parking fees and second the royalty for streaming. In fact, but the younger generation is different. They are willing to pay. And this leads to the comprehensive or inclusive use of the subscription economy. Since I subscribe to Netflix, I rarely download individual content. But such system is not provided in our sector, and that is why we are seeing proliferation of scan files.
As for Professor Kim's question, yes, thank you for your good questions. First of all, the redundancy of payment. Yes, theoretically, we don't really see it as a redundancy. So remember, the guideline says 1 to 10%. So that means that if you're using 1% or less, you don't have to pay a remuneration. So theoretically, if it's fair use, you're not supposed to be paying remuneration. And if you look at the remuneration for the educational material, it was based on a survey that was performed. And if the survey results came out to be something like 500 pages, then the remuneration would be set at a criteria of less than 500 pages. And so the remuneration has indeed is lower. So theoretically, of course, it's not redundant, but realistically, yes, I think we have to take that into consideration. And then the TDM exception is in some of the bills that are tabled at the National Assembly right now. And I think Professor Tae-Lee is going to talk a little bit more about this, especially what was discussed at the AI working group. I think, as far as I know, even if the TDM exception is passed, the current bills that are pending do not include a remuneration. I personally think that remuneration is a costly scheme. It's not easy to adopt. And there's also the transactional cost as well, the cost of levying the remuneration. And when we talk about data for AI training, the transactional cost that is occurred might be higher than what the rights holders may eventually receive. So I think we have to be quite careful. And databases can be used according to the current law for research and academic purposes. On the other hand, many ministries are making AI-related provisions in different bills, and if you look at the several kind of legislations that were revised, it seems that data is seen as a property.
저작권보다는 오히려 그쪽이 더 걸림돌들 가지고
then I think that might be more of a barrier to AI development rather than copyright.
저작권을 비롯한 IP의 법 체계를
Because
고려해서
copyright and IP legal regime has to be considered, but right now it seems that there are many bills that are coming up that are not very compatible.
저작권은 니네가 알아서 해. 이제 적응 범위 정하게 놔두고 꺼내고 있는데 여전히 이게 정리되지 않는
And I still feel that there are provisions that are inside the bill right now that are not very clear. So yes, that'll be it for my response to the several questions that were given to me. So are there anybody on the floor who would like to ask a question to the speaker? Please raise your hand and I will give you a microphone. Or it could be a comment or it could be a question.
예, 프로에서 완벽.
So I think our discussion covered everything. We were introduced on the legislation in Germany with regards to remuneration in the law of Germany.
So it's in Article 60 and it allows 15% under remuneration. And so it doesn't really differentiate between the different levels of educational institutions. So today's issue was about the fact that there is a borderline in Korea. And I think that that's because also in Germany, the sphere of public schools, public education is a lot higher compared to Korea. So there is a concept that we need to think about. We usually talk about remuneration. And in international treaties and conventions, it is mentioned as fair and equitable remuneration, not just remuneration, but fair and equitable remuneration. And you probably heard that from Professor Go Chen's speech as well. In Korea, it says substantive remuneration. So then that leads to the question, what do we exactly mean by substantive remuneration? So if we talk about fair and equitable remuneration, then I think we will be able to better understand what exactly do we mean by remuneration. So I just wanted to touch upon the use of this concept of remuneration. So we have heard from the first presentation about the educational contents and equitable remuneration. Thank you very much to the speaker and the designated panelists. Thank you.
예, 이 세션 발표 감사드립니다.
Thank you for the presentation and discussion. Content for educational purposes are often used not only offline but also in the digital broadcasting manner. So when we look at education, we have to look at how the materials can be used as a digital content, and our session was even more meaningful. And we will also take up a research project on how to use these content as a digital content. Now we will move on to the second session on the AI training data exploitation and copyright issues. The second session will be moderated by Professor Park Jun-woo from Seogang University, and the presenter will be Professor Dae-hee Lee of the Korea University.
예, 이 세션 시작하겠습니다.
We will begin session 2. I am Jun-woo Park, teaching at Seogang University. Today, presenters and discussants do not really need any kind of introduction as they are very renowned, but since we have people watching all over the world on YouTube, I will introduce them. When it comes to AI policy, this is the very person who is forming the policies in Korea, Professor Tae-hee Lee from Korea University. He will be presenting in this session. And we have two discussants. First, from Hanbat National University, we have Professor Chang-hwa Kim. And from Kim and Chang, a law firm, we have attorney Hyung-ji Kim. The topic of session 2 is AI, training data exploitation and copyright issues. This topic is heavily covered in the media, and you may be familiar with it. But any countries that have a Copyright Act in place must have complex interests when it comes to this topic, and it is heatedly debated. But concrete resolutions remain elusive, so I'm sure you all have your own concerns and questions, but why don't we listen to the insights from Professor Tae-hee Lee, who will resolve all of your questions and came here all the way for the presentation despite his busy schedule. So why don't we welcome him to the podium.
예, 바로 시작.
I will start right away. Professor Choi covered in his presentation, and although Professor Park said I would have all the answers at hand, that is not true, honestly. Starting with the AI training data and the protection for AI outputs, there are numerous issues. There are some that can be resolved with the theory of copyright, and others have policy answers, but there are no concrete right or wrong answers. It is an issue more complex than Article 25. We almost need something as drastic as the French Revolution to resolve all of the issues at hand. But I will focus on copyright issues surrounding the generative AI. When we talk about AI issues, we often refer to the value cycle of AI. We use web crawlers or web scraping to collect data, which are then pre-processed. Then it leads to the formation of the AI model. AI model were often referred to as foundational model, but today we say the general AI. So if general AI is produced, it could be serviced right away, or it could be used by third parties, or it could be disclosed as open source. And then fine-tuning takes place, where additional training material is used, and then it reaches the end user, where outputs of Gen AI is created. So when training data is collected, reproduction takes place, which is the issue present. ChatGPT-3, Llama, Hyperclova. No, Hyperclova X does not disclose the data, but Hyperclova does. So they disclose the training data, but from this chart, we can't get that much of information. Almost 400 billion tokens are used to train them, so that gives you an idea of the sheer volume of the training data used. And books 1 and books 2 are some books that are pirated and illegally copied and uploaded on the internet, but when it comes to the copyright issues, the sources are very unclear. And in the training stage, since the data was already reproduced in the collection stage, when it is actually trained, it is converted into vectors, which does not have copyright implications. Then, what are some copyright frameworks that could be applied to the training data? In Korea, fair use is the only option, and Europe, UK, Japan, they have the TDM exception provision. So in Korea and US, fair use doctrine is the only option, but you must be aware that despite technological advancement, when some flexibility could be provided for using copyrighted works, so it sort of gives a wiggle room for the exploitation of works. It's supposed to be a broad provision, but the issue is, until we have a decision of the court, we will never know if a certain case is fair use or not. There are 20 or 30 litigations ongoing in the US, but in Korea, no litigation took place. We often discuss whether a case is fair use or not, but they almost never make it to court. In Korea, which is a dilemma that we face in this country, we prioritize the development of the AI industry, but if that is true, then we have to see that the current reality is not favorable neither to the producers nor the users. The reason that Korea was not able to adopt TDM exemption, despite the bill being proposed by Assemblyman Do, soon the ChatGPT 3 was released into the market. I believe every one of us here were quite shocked when we first saw what ChatGPT 3 was, because it was something we've never pictured before. TDM exception looks at whether the use is commercial or non-commercial and whether the idea expressed is enjoyed or not. But Europe, UK, and Japan all had TDM exceptions in place. Well, Japan could be facing a dilemma because in case of Japan, even commercial uses are allowed under the TDM exception, and lawful approach or the interests of the copyright owner are some rather abstract criteria. So when it comes to big data analysis and AI research, Japan is almost paradise, according to an expert. But after ChatGPT's release, I was keenly following Japan's development, and their authorities are not making any special comments since the release of the model. They are just reiterating the principles. I mentioned the value chain of AI. After the point of big data analysis, the following stages could correspond to a fair use case or TDM exception case. After training takes place, it could lead to similar AI outputs as the material that was put in. So, all stages of this chain are interrelated, so that is where the copyright issue arises. With regards to the TDM exception in UK, the KIPO, which is its national authority for copyright, said that they currently might expand the exception provision to commercial uses, but were met with a heavy opposition from the creatives. So, the commercial and non-commercial use and distinguishing between the two is something that where we should consider the interests of the creators, and UK ended up not including commercial uses under its exception. So this is a critical line, whether it's commercial or non-commercial. When it comes to generative AI, are there any models that only train on the data and do not produce any outputs? The DSM directive of EU Article 3 says that research or cultural institutions using the works constitute fair use, but when we look at the general use cases, are there any models that are not used after just training on the data? That is why the criteria about whether it's commercial or not and its enjoyment of the idea or not is important. Korea has a fair use doctrine that is almost identical to what the US has in place. And non-expressive use is a key element. All AI developers are hampered at this point, non-expressive use. And the best case in point is whether United States is singular or plural. There is no clear answer, but one of the services that Google provides is the Ngram service. And when we searched it here, until 1860s, United States was used as a plural noun, but after that point, it was more often used as a singular noun. And we were able to find this out because around 10 years ago, Google scanned tens of thousands of books and provides the service HathiTrust. So out of 10,000 books, we look at how many cases there are where the term United States was used as singular and the number for the plural uses. So we can look at simply just that, whether it's used as singular or plural. So this is a case in point of non-expressive use. And if you look at the Authors Guild versus HathiTrust, this was a case where the idea or emotion expressed was not enjoyed. And there are 4 criteria for fair use, and the first and fourth are the most important. And when it comes to the first factor, Judge Evil set the decision that became a precedent about transformative use. Transformative use means whether the user added something new and altered the first. This is very difficult to decide on. When we look at the HathiTrust service, it works in this way. Students of 11 colleges, including Harvard, use this service. They enter the keyword and they see results, and this itself is not an infringement. But to provide such service, they had to copy existing books. So intermediate copying is what took place. So copying tens of millions of books to provide this service. The intention was not to enjoy the works, but it was an intermediary step to provide this service. And the U.S. court ruled that this was fair use, and the same goes with the second case. The papers that students submitted, is that fair use or not? To judge whether it's plagiarism or not, the report has to be copied and uploaded. The purpose is to decide whether it's plagiarism or not. It is not to use the work itself. So that also is intermediate copying. AI developers argue with this argument. They are creating outputs that do not infringe on the copyright of the works. And that is their defense, but the court will have to decide. So right holders and developers, they are all making arguments that favor their positions. And when it comes to transformative use, there is the famous Andy Warhol case. This work on the right is Orange Prince. It is a reproduction. A key element in deciding on this case was whether transformation took place by adding a different purpose and character of use. It has to be justified. And in this case, the black and white photo on the left was the original work taken by Goldsmith, and the right is the work of Andy Warhol Foundation. And if this work was produced for a commercial purpose, as long as there are no other factors to justify the use, then that is not transformative use. Then what if we applied this logic to AI training? That would not be in favor of AI developers. And it's a handsome gorilla, right? Almost looks like a chimpanzee version of Brad Pitt. His name is Naruto. So some selfies turned out really nice, but this is not a work that was taken by humans, so it cannot be protected under copyright. In fact, the idea of human author comes from the 18th century concept of romantic author. Before then, if we look at paintings, well, the view was different, but in the 18th century, romantic author concept was emerged, where they would have this romantic view of an object. So we have the utilitarian approach and the moral rights approach and the natural rights approach. But if we look at the natural rights and the moral rights approach, they do not apply to any author that is not a human being. So, utilitarian theory of copyright law might be a possibility here, which is based in the common law. But whether to limit authors to human beings is a policy decision to be made, and Thaler is a very significant individual. I think he is aiming to get some noise marketing, but he is leading to some useful and interesting precedents in the copyright sector. And the U.S. Copyright Office rejected registration of Zarya of the Dawn, but China's internet court recognized AI output as a copyrightable work. In Beijing Internet Court decision, they looked at the input of positive prompts and negative prompts and adjustment of the parameters, and then reiterated this process for 3 times. So the court deemed that human contribution was present in this case, but in the U.S., the action of putting in prompts is far away from the final output of the AI model, so they do not see it as a human contribution. So those are some different approaches. And the last point I would like to cover is the disclosure of training data, which is a wish held by many copyright holders, but it's not an easy issue. EU has this legislation prescribing how to disclose training data. The AI office provides a template which has not been disclosed yet. There is the issue of trade secrets, among others. So it will be quite a tall order, but in some lawsuits, the copyright holders are demonstrating that such prompts could lead to such outputs. And I would like to mention the approach that EU is taking for AI. The EU AI Act is in effect. If we look at Article 52, Paragraph 1, Section C, it says the training data has to be disclosed, which in itself is significant. But an even bigger implication is that general purpose AI model developers must comply with the union law on copyright and related rights, which is obligating acquisition of permission. But there is an exemption, which is the TDM provision. When it comes to TDM, using recent technology to identify the reservation of rights of the right holders is necessary. So the EU AI Act in relation to the DSM copyright directive are implying that we need the permission from the right holder, which may not be very feasible because the US copyright regime is heavily opposed to the opt-out of right holder. So the right holder can opt out for the data on my website, but they cannot opt out for the use of their work which is uploaded on a different website. So it is not very practical to exercise. That is why the right holders in the US are very against the opt-out system. And opt-out itself is based on TDM, so it is part of the limitation provision of copyright. But, well, is it statutory license or fair use or exemption? This is a complicated question, but I mentioned the French Revolution in the beginning because to determine all that out, we have to first resolve the issues surrounding fair use. So you need permission for training data use, or you need statutory license for something else. This all comes after we've resolved the fair use problem. If we skip that theoretical part and just legislate statutory license for training data, then all of the musical works right holders are for the permission solution. But the musical works right holders and the photographic work right holders are saying getting permission is possible, so why are you opposed? But Professor Choi said that US right holders are against statutory licensing also because the royalty rate, equitable remuneration is very difficult to determine, and the copyright royalty border is applied for statutory licensing, but it takes years to come up with the amount, and it is inefficient. And AICCP is against the idea of extended management. It is only feasible in some Nordic countries, and we don't have enough experience. So even if we promote statutory licensing, it will take years to be implemented, but 6 months is forever when it comes to AI. So Korea needs a drastic measure like the French Revolution. One last point. If we look at OpenAI and other AI makers, they reached an agreement with a lot of media outlets. And I think the US parties are quite smart. So RAG and search services are included in the AI outputs, and media outlets need those data and information. So these big players get the permission that they need. That concludes my presentation. Thank you.
예, 이대희 교수님 발표 감사히 잘
Thank you, Professor Lee, for your insightful presentation centered around TDM provisions and fair use provisions. You have walked us through the copyright regime and exemption provisions in place in various different countries. Now we will listen to the discussion of Professor Kim and Attorney Kim. So we will hear both discussants and then hear Professor Lee's reply. So, Professor Kim.
Hello, I'm Kim Changwa Kim from National Hanbak University. Thank you very much for your presentation, Professor Lee. So I have two questions as my intervention. Actually, in the last part, you did mention the idea about the opt-out, but I believe that opt-out could be a good option, a good methodology in training of AI models. And so having said that, I would like to ask you why opt-out is needed, and I wanted to ask you what you think about introducing opt-out in Korea. But you already mentioned that the Americans are against it. But nonetheless, even if there are some technological issues, I think right now the EU AI Act has the opt-out, and the Single Market Directive also has the opt-out. And actually, if you look at the opt-out scheme, it's quite befitting to the internet and to copyright, because it's not about the right holders giving permission, but it's allowing the free use of works unless there is a reservation made by rights holders. So I think it promotes a freedom of use in the internet, because internet, after all, is a very open space. So because of the characteristics of the internet as an open space, I believe that the opt-out is the appropriate method. Of course, a lot of the Americans are against it, but it's the first time I actually heard that. When I read the American articles, I had actually concluded that they were indeed speaking more positively towards opt-out. But Professor Lee, you said that they were against it. So I think it's more on a policy level that the policymakers are against the opt-out scheme. So in Europe, it seems that opt-out has been legislated, but there are some critics because it seems that the opt-out can give more discretionary powers to the right holders, according to some critics in Europe. But nonetheless, I think opt-out could be a good way forward for use of data to train AI models. But maybe Professor Lee can elaborate a little bit more, and I think that would be very helpful. So this is my first question. The second question pertains to AI and the issue of authorship. It's in my submission to the conference proceeding, but AI, if you look at the social value and the outputs generated from AI, and the fact that even corporations are recognized as a right holder, I believe this is really a matter of policy. And I think in this regard that, of course, we are not recognizing the authorship of artificial intelligence. But going forward, I think in the future, it will be difficult not to recognize authorship of AI, because especially when it comes to generative AI, and there's going to be the output, and also the copyrightability is eventually going to be recognized going forward, I think. So then that begs the question, who should gain copyright? There was an American report that just came out, a guideline on generative AI and copyright law, and the user of AI who had induced the creation of a certain output should be considered as the author and limited to the author. But of course, the coders should eventually also have some copyright protection. So, if we were to recognize the copyright of AI-generated content, who should have that copyright? That's my second question to you, Professor. So that's it for my intervention. Thank you. Thank you. Ms. Kim?
For years, in the academia and the field of IPR, generative AI and issues surrounding generative AI and copyright has been heavily debated, and I would like to thank KAIP, Alai, and all hosts of today's event for preparing this meaningful venue for discussion. Since the widespread adoption of generative AI, not to mention the producers and the users and the sellers in the cultural content industry, but even other manufacturers and IT players are being embroiled in copyright issues with regards to AI. And Professor Tae-hee Lee is the top expert in the field and shared his insights and perspectives on AI and copyright issues. So thank you once again for your presentation. He mentioned AI training data and whether it falls under fair use and the protection of AI outputs. And although this part wasn't heavily mentioned in the presentation, I would like to discuss those points along with the application of the provision for works made for hire. First, looking at whether fair use doctrine can be used, as Professor Lee mentioned, before we see the decision of the court, it is very difficult to figure out whether it is fair use or not at the time of training. The fair use provision we have is similar to what U.S. has, and looking at the Federal Supreme Court decision on Andy Warhol case could be helpful. However, in Korea, the first criteria for fair use determination is the nature and purpose of use, and it does not limit to only non-commercial uses, but when it comes to commercial uses, then compared to the former, the scope of fair use is much more limited. So at working level, we often advise our clients that commercial uses will not usually be recognized as fair use. And in the Andy Warhol case, the court focused on whether it was transformative use or not. In the first instance court, it decided that Andy Warhol added new expression leading to new aesthetics on the original work of Goldsmith, so recognized it as transformative use, but the Federal Supreme Court deemed that Andy Warhol Foundation licensing the Orange Prince work to the magazine had the same purpose as the act of publication of the Prince's portrait. So it made it commercial use, which rules out the transformative use justification. So rather than the aesthetics or the change in the significance of the work, objective facts and aspects were prioritized when determining whether it was fair use or not. And we've seen another case that seemed to have referred to the Andy Warhol case, when it comes to the nature and purpose of use. If the use makes transformation by adding expressive factors, or whether it added transformative elements to make the original work reach a new level and was not merely extrapolating non-expressive components. These were considered, and in the case where an entire book was reproduced and 4 publishers raised a suit, even if it's free lending, which is not commercial activity, it still does not fall under the fair use category. So fair use cases rely on the facts, but the reproduction action itself that takes place when it comes to AI training data, there won't be much differences. So the action of training AI model could be seen as extrapolating non-expressive components. So it is perhaps transformative use, or it is to provide commercial services to the users, which makes it not transformative use. So I wanted to hear professor's comment on this, but I think this question is already answered. And the next point I would like to raise is the rights attribution of AI outputs. And I wanted to ask the professor about the principle of law. AI outputs, of course, when we look at it from the provision that defines works as an expression of human beings' ideas and emotions, AI outputs does not fall under the protection of copyright, and MCST and KCC also rules that or prescribes that alteration has to be made on the AI output by a human being, making it a derivative work or making it a compilation work through editing and arrangements. Unless that is the case, then human authorship cannot be recognized. And there's the issue of AI prompts. So there are some arguments where works for hire doctrine can be applied to recognize the rights of the AI service provider. Taylor indicated that the author was the creativity machine and registered the work as a work for hire, but the USCO pointed to the lack of human authorship for rejecting the registration, which was once again recognized by the Federal District Court of Washington, D.C. Korea has a little different approach. When it comes to work for hire, it has to be a work that has been produced on duty by an employee of a corporation under the planning of the corporation. And whether we could expand the scope to include not only human beings, but also corporations and associations here, that expansion has been made. But there is still a question surrounding whether it cannot be a natural person, whether the employee can be a non-natural person. So this is also a question that I wanted to direct to the professor, and that is the end of my discussion. Thank you. Thank you for your points. So I think fair use and works made for hire are the topics of the question. So
the first question posed by Professor Kim is not really the U.S., it's some of the copyright holders in U.S. who are against the opt-out. So the USCO regarding AI issued a guidance, and it said that a lot of the copyright owners were against the opt-out. And what we have to think about when we think about the learning data for AI, there's already data that's being used, and there are the future use, and we have to be able to differentiate the two. The ones that are already being used, it's unfortunate, but it's not really easy for the copyright owners to find relief. Maybe they can sue for compensation for damages, but it's not really clear how they will be able to be compensated. Do you remember the Soribada case? The rights holders got less than 20 million Korean won. So remember, there's that fine-tuning, and there's the rack, and a lot of the use is focusing on the rack. And so the generative AI developers are going through this process of hallucination. And in order to be able to prevent this kind of hallucination, they have to be able to come up with high-quality content. And that requires news articles and also school textbooks, because the two kind of contents are very high quality and very accurate. And so there's a high value in their use. And also, another thing that posed by Professor Kim was that I don't really think the European approach is necessarily correct. So American companies have a high domination over the European market, more than the Korean case, in fact. So under these circumstances, I'm not sure whether that kind of AI Act is going to really help the development of artificial intelligence, or is it going to help the users? Neither, I think. But I don't think law has any kind of solution to these issues. I think it's really of a matter of policy to bring the different stakeholders together. Everyone needs AI, but we also have to take into account the interests of the right holders. So I think that's sort of the American approach. I'm not saying what's right and what's not right. Trying to get statutory licensing, that's just going to take forever. And then there's going to be a bigger lag. I don't know the question of who should gain the copyright. There was a mention of coders. There's the CDPA, the biggest contributor. In UK, there was a mention of the developer, but that was not really, it's not really connected to AI. So ultimately, the person who had contributed the most would eventually be recognized as the author. And nowadays, the prompts can become really creative, and it can have a huge impact on the output. So the person who inputted the prompt could be the biggest contributor in that kind of case. And for work for hire, yes, you did mention the fact that it's a legal entity, but it's nonetheless still have to be indirectly being created by a human. Of course, people like Dr. Thaler asked the question of if there is an animal who gives birth, who's the owner? So if you own a fruit farm, do you also own the fruit? But then there's the other side of the argument. The tree gives fruit, and animals give birth. And the problem of creating an artistic work are completely different, some people would say. And when it comes to work for hire, the employees of a company who are also humans are the ones who are the creators, but also the work for hire guarantees rights for the legal entity as well. So I think we can entertain some questions or comments from the floor if anybody has one.
예, 안녕하세요.
Hello, I am Professor Kim from Sangmyeong University. Rather than a question with regards to rights attribution, recently Professor Kim made this comment in a seminar in Stockholm, and this reminded me on why humans cannot be authors, and I wanted to share this insight with the group. Professor Kim Chibok said that AI can rarely be recognized as an author because when human beings create something, they usually have an idea of what they want to make, and whether the execution was good or not, they predict what's going to be the outcome. But when AI makes something, sometimes their output is ridiculous, very different from the prompt. So even if human beings provided the prompt, it is difficult to see human as the author for AI outputs. Last year in Paris, Alai held a meeting, and the theme was AI. On the first day, the focus was on upstream, which is the input, and the second day focused more on the downstream, which is the output of the model. And when it comes to rights attribution, it was part of all discussions throughout. And the perspective of presenters all agreed that if AI assisted an output and the output is used for recreation, then human user can be seen as the author. But if not, then according to the treaties or domestic laws, they can rarely be recognized as the author. And in Europe, sui generis approach should be taken, or the neighboring rights approach can be taken. The work can be transmitted, but content that is not the work can also be transmitted. So it makes it clear during the transmission, if a work that is too identical to the original work, then the prompt, the user who gave it the prompt should be accountable. So this is an approach taken in the research, and I thought these could be helpful insights. Thank you.
Thank you. So I think there's no right answer for now, but there is one thing that's quite clear that we can all converge on. We talk about the copyright policy. What are the aims of the policy? It's in Article 1 of the Korea Copyright Act. How can we maneuver the copyright policy and regime so that it is beneficial to society and culture? It's a matter of policy. It's also a very philosophical question regarding humans versus machines. Many people fear that humans will be subjugated to machines. So this is not just a copyright issue. It's an ethical, it's a religious, it's a philosophical issue. Thank you. Professor Han? Thank you very much, Professor Lee. It was a very interesting talk. On page 8, it talks about training data and the use of training data and the copyright issues, and you have made a comparison between the laws regarding the limitations and exceptions. But in the case of TDM, you have the continental legal tradition, and fair use comes from the Anglo-Saxon tradition. Well, yeah, UK excluded because they have the TDM exception, unlike the US. And then you both have both the TDM and fair use in Singapore. So in Korea, there was a political dynamic regarding the Korea-US FTA when we adopted the fair use provision in the Korean law. So up until now, we've had a discussion about what implications it has, but not so much on the applicability. And I think nowadays we're having more of a discussion on the applicability on the ground. So we do have an American fair use provision, but we don't really have a jurisprudence regarding the fair use. We tend to depend on some of the judicial precedents come from the US, like the Andy Warhol case. And we are basically in the level of researching and analyzing those kind of judicial precedents. Article 35 on fair use have not really been applied by the courts based on its own analysis. So having said that, in the case of Europe, the attitude differs from that of US. So there's a lot of innovation in the US, and there's a lot of support for AI developers. On the other hand, in Europe, people are a bit more wary and more cautious and try to regulate and control AI more. So Korea has a continental legal tradition, but it has an American provision regarding their fair use. But now then, on the other hand, we have a bill pending that includes the TDM exception. So if we legislate that, then we would have a Singaporean model of having both the fair use and the CDM. But Singapore is also following more of the Anglo-Saxon tradition in general. So if Korea adopts the TDM exception, then what would be the role of the fair use provision in Article 35? So Professor Lee, do you have any take on that?
계신 분들 누구든지
Anyone here, when ChatGPT 3 was released in 2021, before that point, I don't think anyone was opposed to the bill of Assemblyman Do for TDM provision, but things changed after ChatGPT 3's release. So the exception to copyright infringement sometimes address specific cases, and there are general provisions, and fair use is the general provision. And when we say we need to legislate TDM provision, it's not what Mr. Do proposed, but at least some of the cases of the TDM cases are fair use cases, and that is something that has to be covered through legislation. If we look at all the individual cases, they might all fall under the fair use, but they have been specified. So if we legislate a TDM provision that falls under fair use, then some ambiguous cases would have to rely back on the Article 35. So it would be a circular reality or practice. Thank you. Just one very last question, if you could make it brief. Thank you.
예, 저는 발표 잘 들었는데.
Thank you very much for your presentation. You talked about data training and whether it falls under the fair use or not. So it could be expressive versus non-expressive use. When we use AI, there's the data that has been used, and the output could be similar to the trained data. Of course, it goes through various stages, and there could be the separation between expressive versus non-expressive use. But in that process, the barrier or the line between the expressive and non-expressive is not very clear. Of course, it's not clear. So, and there is no answer. So, non-expressive use is number one of the 4-step in determining fair use. But just because it fulfills number one, that does not mean that the use is fair use. But the American courts tend to focus on number 1 and number 4. But I think rights holders tend to focus a little bit more on number 2 and number 3. Because number 3 is all about the entirety or the partiality. And also the number 4 is, I think, about the impact on the market. If you look at the newspaper, a lot of the newspapers use Getty images a lot. And there may have been a lot that have been generated by AI too. So have those AI images decrease the market for Getty images? And then when we talk about non-expressive use, if it's training, I think it's non-expressive use. But then if it's big data analysis or AI training, well, it's all about collection. And then there's the picture engineering. So when some characteristics have been extracted, and then there's it vectorized, and then it goes through a computerized process. And the ultimate output is the one that has the highest probability in terms of statistics. So it is indeed non-expressive use. But it's really crazy because then it is about generative AI.
돼서 이상으로
We are way over time, so we will have to close session 2. Thank you to all the presenters and panelists.
예, 아주 너무나 예 발표 잘 들었고요. 예, 저희
Thank you for the presentation. AI training data is a key part of our research projects. A lot of the work is used to produce in broadcasting agencies and digital content. So how the outputs are used in broadcasting is also a key issue and will further be researched. And although we are behind schedule, we will have a short break until 4:35 for 20 minutes. We have coffee ready outside the hall, so please enjoy our refreshments. Thank you.
잠시 후 컨퍼런스
We will begin the second part of today's conference shortly, so I would like to ask all distinguished guests to take your seats.
지금부터
We will now begin the last part of the 2024 KIIP and Alai Literary and Artistic Works Copyright Conference. Good afternoon. I am Jung Soo-yeon from KIIP, who will be the host for this part of today's program. The third session of the day will focus on the fair use of literary and artistic works and quantitative criteria. Please, may I have the moderator and discussants for the third session come up to the stage?
세 번째 세션의 좌장은
The moderator for the session is Professor Sang-yuk Cha from Gyeongbuk University. Please give him a big hand.
예, 제가
Hello, I'm going to be moderating session number 3. My name is Sang-yuk Cha. I'm a professor of Gyeongbuk National University. I would like to thank you for bearing with us until nearly the end of today's conference. I think we are running a little bit behind time, but nonetheless, I think I do have to introduce the presenters and the panel discussants, and then I'll be giving the microphone to Dr. Park. So first of all, we have Min-seok Park, an Associate Research Fellow from KIIP. And then we have panelists. We have Se-chang Kim, Team Lead from SLL. We have Mr. Dong-pil Shin, a member of the Korea Commission for Corporate Partnership. Nare Lee, a member of the Korea TV and Radio Writers Association, and Tae-hyun Kim, the president of the Writers Association of Korea. So, are you just going to make your presentation sitting down here? Okay, with that, I'll give the microphone to Dr. Park.
예, 오늘 발표
Hello, once again, to introduce myself, my name is Yoon-seok Park. I'm a research fellow of KIIP, so I'm going to be talking about the fair use of literary and artistic works and setting of a quantifiable criteria. So I know that this topic can be quite a provocative one because we're talking about quantifiable criteria. because when we talk about criteria for fair use, the courts usually talk about the comprehensiveness and various factors are taken into account. But then we are now talking about a quantifiable criteria, like coming up with a certain percentage that can be used. And so let me try making a presentation about what this may mean.
예, 마이크를 바꿔서.
So I'm going to be changing the microphone. So I'm going to be talking about the enforcement of IP and uncertainties, fair use and royalty, fair use and quantifiable criteria, the elimination of uncertainties regarding fair use, and then the issues regarding the quantifiable criteria. So number one is about uncertainties regarding enforcement. So if you go to a litigation, you cannot guarantee who's going to win ultimately the litigation, because whether there's creativity, whether there's similarity, the court will ultimately make the decision. And in the case of patent-related litigation, they are the possibility that both patents will be cancelled. So, there were many cases between Samsung and Apple, and the more they go to litigation, the more the patents will be eliminated for both sides. So there are many uncertainties regarding enforcement of IP. So there are warning letters, and there are some research into the statistical aspects about this kind of enforcement. So even the law practitioners and experts, there's uncertainty. That also means the layman will have more of an uncertainty. How much are you allowed to use or not allowed to use? It's very unclear. So there's a Metal auf Metal case that's pending in the German courts, and it's the litigation has been going for 20-something years over just 2 seconds sampling from the metal on metal. It's a very short sequence. And as a person who does not know music, the 2 seconds seems like a really, really short excerpt. But this itself is becoming problematic. So people from common sense may think that 2 seconds is really short, and it's not a problem with copyright. But those who know copyright would know that even if it's 2 seconds, if it was for commercial use, then it could become problematic in terms of the copyright law. So ultimately, like I said, the court determines whether something falls under fair use or not. When I was working for the KCC and I would go to lectures, people would ask questions about the criteria for the remuneration for educational material, and people would ask me, what's the scope? And I would usually answer within the reasonable scope. And then they would ask, what's reasonable scope? They would ask me, is it 1 minute enough, 2 minutes enough? How about 5 minutes? That's how the question would evolve, and then it becomes really difficult. So quantifiable criteria is actually a convenient tool for the general public. But coming up with a quantifiable criteria is difficult to come up with consistently across the variety of different works. So if we do have a quantifiable criteria of enforcement, I think would also be easier, as well as the use. So before we go into this issue, let's ask the question, is fair use free? If you look at TRIPS Article 13, there's a provision on limitations and exceptions. And many people do believe that fair use is free use, but getting permission to use a work and then paying to use a work are two completely different things. Not getting permission may nonetheless mean that you do have to pay, because that may be a remuneration. So that means ultimately that fair use is not necessarily free of charge. And so I believe that there could be a separation between free use and also licensing, with the remuneration and also licensing. And if you also look at some other cases, you can see then the private copying levy is imposed on device. And the people who have developed that kind of technology is then also paying the relevant costs. And so it might not necessarily be the users, but somebody else who may also have to pay remuneration. And so I think we can turn this concept around a little bit. And so when we talk about fair use and the quantifiable criteria, we first of all have to think about the issue of this royalty. So people ask, is 5 minutes okay? I don't have to pay for 5 minutes. No, that's not the right question. You do have to pay for 3 minutes or even 5 minutes, but 3 minutes and 5 minutes can be used without permission, but nonetheless, you do have to pay a remuneration. So that's the kind of system that we need. So when we talk about fair use and the quantifiable criteria, you have the fair use provision in the Korean Copyright Act, which is Article 35 quinces. And so where a person does not unreasonably prejudice an author's legitimate interest. And then there are 4 different factors that have to be taken into consideration when determining if something is fair use. So if you go into detail for each and every one, there are a lot of things that are not really clear. So if you talk about the amount and substantiality of the portion, that sounds easy, but if you think about broadcasting or literature and artistic works, so for example, if you think about a novel, a particular novel, people may be reminded of the entire novel just by reading the title or one single sentence. And there are poems that are very short, that are very succinct. And somebody might resort to one sentence or one phrase in a poem, but that one phrase might be symbolic of the entire poem. And so quantity-wise, it may seem a very small part of a work, but symbolically and qualitatively, it could take up a substantive part of the work. And so sometimes maybe a citation can be for the entire work, but usually citations are for a small part of a work, but nonetheless it could be quite symbolic. And then there is a fair use and copyright infringement determination model. We can look at the effects of the uncertainties around fair use and determination, usability of the fair use system, and that was analyzed. So the model bears in mind just one thing. Did the broadcaster wants to use one sentence? Is it fair use or not? That could be the premise for our determination. From the broadcaster's perspective, of course, they would use it if it's fair use. If it's not going to be fair use, then they would have to get permission or they would not use that particular work. So when we are setting this kind of model, let's have a promise. So let's say there's an outsourced producer and is trying to use somebody else's work for 3 seconds, or maybe it could just be one sentence to make a broadcast work. So the premise is that the right holders is not going to file an injunction against the use of the work, because the right holder, if he or she resorts to an injunction, can prevent the entire work from being used. So the premise should be that only a financial remuneration is being requested by the rights holder.
그래서 약간
So I came up with a formula. The chances that the outsourced company constitutes fair use, let's say that's P, like 30%, then the probability of it being unauthorized use is 70%. So unauthorized use equals 1 minus P. That is the probability of copyright infringement. In that case, litigation cost would be borne, and on top of the royalty for the use. So litigation cost is C and royalty is R. So when the chances of unauthorized use is 1 minus P, that person would have to bear the cost of C and R. In that case, the user of the 3 seconds of the work would have this expected value, which is E. That would be 1 minus P, which is the chances of unauthorized use, times minus C minus R, the litigation cost and royalty. So that sums up the cost of unauthorized use, plus P, which is the chances of it being fair use, which is not this case, times 0. So that results in the expected value. And there is no cost incurred when it's fair use, so that is why I added P times 0. That would result in this formula. P has to be larger than C over C plus R. P is the probability of the use being fair use, C is the litigation cost, and R is the royalty for use of the copyrighted work. So when we take this premise, C plus R, so C over C plus R, if that becomes larger than P, then it means we can use it as fair use. So P, let's say, is 90%, then C over C plus R. As long as it is below 90%, then it is worth taking the chance. Or else there is the risk of being sued, so it's not worth taking the chance of using the work. So C plus R 1 over R over C plus 1 is another way to express this. So R over C is what impacts the probability of fair use. So how much is the royalty and how much would the litigation cost be? The size of that ratio would impact the decision on whether we will attempt at this potential fair use or not. When the denominator becomes big, then the whole value is reduced. And if numerator is big, then the value becomes higher. So if C plus R goes up in this case, that means the denominator is larger, so P would be reduced. So the probability of fair use would be reduced. If the denominator is reduced, then in relation to the right side, the size of B or the amount of P would be bigger, so higher chances of it being fair use. So if the chances of the case being recognized as fair use is higher than 90%, then we would consider the potential litigation cost and the royalty and its ratio to P, and one might deem that it's worth it taking the chance of using the work. But if the royalty is less than 30%, even if the fair use probability is only 30%, if the royalty is not that high, then the user might be willing to bear the risk of the cost. So when we surveyed broadcasters, when they use a certain material for broadcast, if there's even 1% chance of copyright infringement, it is practice that they would just forego that content. So the copyright limitation in relation to broadcast are in the form of many provisions, but still they're not really applied in practice because broadcasters are not willing to take the chance of a litigation. That shows the amount of uncertainty. If we can get an idea of if this is 100% infringement or 100% fair use, if we can get that idea, that would really promote the use of fair use doctrine in practice. So, in order to make the fair use provision more practical, there has to be a clearer criteria for fair use. We heard a lot of comments in the presentations, and there were some cases where quantifiable measures were put in place. In Germany, 50% in educational institutions, and in UK, 5% or less of the work within 12 months, and in the US, 10% of 1,000 words. And in Korea, during the COVID-19 pandemic, in a virtual setting, 20% of the entire content, maximum being 15 minutes, was the criteria set by EBS. If we didn't have that criteria, laymen would have no idea how much of a content they would be able to use for education in virtual settings. So such criteria are very significant, but they have their own problems. If we use a portion of a work, can we deem that as using the entire work? We ran statistical analysis for C, and the average number of words with a C totaled 59. And if we take 10% of that, that would result in 5 words. But 5 words being fair use, 5 words is too less. So that means that is really not practical. If we're going to use a poem
of a matter of an approach, but also are we going to just recognize just the continental legal tradition? Are we going to approach it as a debt or as a property? So we have to decide on the approach first. And that also leads to a whole lot of other questions. The German Federal Court made a ruling on metal on metal, and if you listen to that music, it's a band music. And it's sort of like this bullet train. It's very machine-like. And it sounds indeed very metallic. Like the bullet train on a track. And so you have this rhythm, and then there's this drummer making a drummer performance, and this metal-on-metal case is pending in the German courts for 20 years. And the German perspective was that it was indeed an infringement of copyright, but then the Constitutional Court came up with a different ruling and saw it as a conflict with the basic rights. And so you have the European interpretation, then you have the national interpretation. So you have the Article 124 of the German law, which also conflicts with the European directive, and this is why the Constitutional Court did not accept the case. And so there is still the issue of how this case is going to be dealt with in the German court. So even in the US, there is a similar kind of case pending in the courts about something like a 6-second use. And so the circuit courts also have a differing idea from one another. So the conservative tendency would be that just even 1 second could be seen as a violation. And then there are a little bit more liberal side who may think that it could be 0.4 seconds or 6 seconds. We should be focusing a little bit more on fair use and the free use of work. So the different circuit courts in the United States have differing ideas, and in Southern European Union there is rather a lot of confusing perspectives. So this kind of partial use or citation is leading to a lot of debate in many different continents. And so I think Dr. Park's presentation was provocative in the sense that it gave us lots of food for thought. So, first of all, we are going to listen to Se-Chang Kim from SLL, a team lead at SLL. Maybe you can contribute to the discussion. Hello, I'm from SLL. My name is Se-Chang Kim. So we are talking about the quantifiable criteria, and I would like to thank Dr. Park for his presentation. He talked about the uncertainties regarding the fair use and the need for a clear criteria, and an approach was proposed, i.e. the quantifiable criteria. I thought it was very insightful. So let me just briefly introduce my company before I actually go into my intervention. SLL is a studio that makes a lot of TV dramas and also entertainment shows. We have 12 labels, and we have produced about 380 programs, about 20 to 30 per year. So it's one of the biggest drama content producers in Korea. Also, we give programs to TV and Netflix and JTBC. So the reason I just told you a little bit about SLL is that even the biggest studio also ponders very deeply about whether a citation, a small citation, can be deemed to be fair use or not. And so I would just like to briefly talk a little bit about some of the dilemma that we face on the ground in practice. So we face a lot of challenges. Let me just give you a few examples, and at the same time I'm going to be asking some questions. Recently, I got a question from my producer. There are 5 characters, and they are acting, and the protagonist is going to act on a certain line in the script. So let's get started. That's the line in the script. Does that have to get permission? Because it was used somewhere else. You don't know what I'm referring to, right? Because it's a general sentence. It's not protected. But if I say 자 이제 시작이야 in this kind of intonation in Korean, how's that? Then you would then think, what are you talking about? But then if you think of it as a melody, the people who lived during the 90s in Korea will know what this sentence, because it's the first part of the Pokemon song. So even if it's a really short sentence, it can be very symbolic. Then do you have to get permission to use this or not? So this is a big dilemma. Those of you here will probably be divided into 3. The actor used the song from Pokemon, and it's quite symbolic of Pokemon, and so he should be getting permission. The second group would say, I think it's fair use, or maybe it could fall under another kind of limitation. And the third group could think, we don't have to get permission for that. That's too much. I think we should be free to use that kind of phrase. And then you have the creators. Say there are 30, and so there are 30 people from the broadcasting. And if you ask them what they think, I would guarantee that the debate is never going to end. So it's a very debatable issue, and the people on the ground, the creators, can never find the answer. It's always a dilemma because we are not legal practitioners and we can never make the determination properly. It's impossible to determine whether something is okay or not okay. I am here, you are there. That kind of sentence is not protected. But then if you say, I want to focus on my youth, that could be deemed as a copyrightable and protected. But what I want to bring your attention to is that there's this uncertainty and unpredictability, and what effects do these uncertainties have? So 3 things happen. Okay, we have to get permission. Number 2, it can be fair use. Number 3, no, we don't have to get permission. Just don't use it. Let's just delete it. So there are 3 different choices. The conclusion in most of the cases, number 3, we just don't use the work at all. But then when we are making one drama series, there are maybe 10 or maybe 30 different cases where we have to face this kind of dilemma. I looked at the statistics for one work. There are about 10 to 30 different cases where we have to use a song or a certain line. And then we make about 30 dramas per year, which means that every single year we are pondering and facing this kind of dilemma 300 to maybe 800 different times. And about 800 works will end up not being used by us. So the creators then will not have his or her work used. And although a new market can be created, because of these kind of uncertainties, that market will never be created ultimately. So then there's one on number 2. Oh, let's just argue for fair use, or let's get permission. Why are people not opting for those 2 choices? That's because the transactional costs are unpredictable. Royalties are not set or established. Maybe people say 500,000 or 1 million Korean won. Or then if it's really popular, then people say, they want 10 million Korean won. The royalty is unpredictable. Number 2, the rights holder's response is also unpredictable. So we can contact the rights holder and then we can try to get permission, but then that person may end up not being the rights holder. How are we going to determine who is the right holder really is? There's this particular program that became a big issue because somebody of a popular program pretended to be somebody pretended to be the rights owner of a certain program, but he was not, and therefore was sued. And then why don't we try to get fair use or recognition as citation? But then even if we do make a citation, or if we try to use a fair use defense, and ultimately we lose that litigation and end up being infringement, then the whole drama series can put in jeopardy. And then we would have to go through the entire process of the litigation and investigation, and that also can be quite costly. So that's why ultimately on the ground, producers and studios like us opt not to use the work at all. Then that limits the scope of creativity. So do you know that series, Reply 1988 or 1994, etc.? So it was really popular in Korea and it's becoming quite popular elsewhere also. In January, a producer was on an interview, and that producer said, "Oh, it's never going to make reply series ever again because the royalty was immense. Unless it's a company like Netflix, they just cannot afford all the litigations and all the liable litigations and also copyright claims. So there's lots of music. There are all sorts of use of works that is entailed in making of a drama series. And if we try to get permission for every single use, it's just going to be impossible. And so the producer was basically saying that he's not going to make these kind of reply series that's based on the past. Also, then it's not beneficial for the rights holders either because their market is also shrinking. The market that they could have created by giving permission and receiving royalty is also shrinking. There's also the advertising effect that is also decreasing as well. And so, from creators' perspective, the rights holders' perspective, and also from the users or the producers' perspective, it's a very negative kind of situation that is unfolding on the ground. So, in short, this kind of unpredictability has to be resolved so that creativity and creative activities can be further promoted. Of course, you have come up with a quantifiable criteria, but I would also welcome any other kind of alternative, clear criteria, and I think that will greatly help the people who are working on the ground, practitioners. So I'm not necessarily saying that we want to use everything for free. That's not the matter here. What is important is it stable? Is there a stable provision? A stable supply, or is there predictability and certainty? Not so much. Do you have to pay or not pay? So hopefully, I'm hoping that from this conference and onwards, we'll be able to continue with the discussion, and I'm looking forward to some constructive responses from the academia and the related experts. Thank you very much. I think he had a lot to say. So I'm going to now give the mic to Mr. Shin, Ms. Lee, and Mr. Kim. Please keep your comments a little bit short. Thank you.
Hello, I am Shin Dong-pil from NCCP. So our presenter really covered the implications of fair use doctrine and the improvements needed to further activate it. The first is eliminating uncertainty of the fair use determination. And I agree with that point of Dr. Park. So I would like to add some of my personal opinions. The intention of Copyright Act is to contribute to the advancement of culture and relevant industries rather than protecting the right holders. So in order to nurture the cultural industry, various works must be created and they should be freely used, and we need a conducive environment for just that. Then, as long as the market value of the original work is not undermined, then we should more actively recognize fair use cases. With regards to fair use, we are using the remuneration system for educational uses. That is one option, but another possibility is when drama producers create a title, then they can take a portion of the cost and make a fund of it. And once such a fund is created, when remuneration has to be paid later on, then large conglomerates and the creators could perhaps form a better relationship when such funds are created. And second, I would like to address the transaction cost point. Fair use could be seen as an externality, a positive one. If there is an externality, then it usually hinders transaction within the market because you don't have to pay but just use it. If music is played here right now, then someone already paid for the music because he or she wants to listen to it, but the person sitting next to the person could also listen in on the music that he or she did not pay for. So that is a positive externality. Someone paid the fair cost or the due cost, but a different person could together share the positive benefits of it. Then the easiest way to regulate externality is the intervention of the government. But when Ronald Coase, the Nobel laureate, addressed this issue, he said that if property rights are clear and there are no transaction costs, then trust the market with the distribution or allocation of resources, and you will see the most efficient results. Here, the key is there has to be no transaction cost, which is not the reality that we face right now. There is the litigation cost, and there's the negotiation cost that goes in when transacting copyright. So when we do have transaction costs, then we have to clearly delineate copyright and deregulate to minimize the transaction cost. That would lead to a more efficient resource distribution. We do have a clear definition of the property right, namely copyright, but there are more determinations to be made, which usually ends up being the responsibility of courts. So we have to look at ways and provisions to reduce that uncertainty so that we can minimize the transaction cost and more efficiently share the resources. All of the points I raised are not coming from a legal perspective, but rather from an economic perspective, how to more effectively make use of the resources that we have. Creating a fund or using the remuneration system could be an approach, or we could further clarify the regime to minimize the transaction cost could be another approach. I think that would provide more desirable allocation of resources, and to achieve that, we need a more clear data. We have a lack of data with regards to fair use. We don't have cases that were studied and not enough analyses. The same goes for remuneration for educational purposes. The system is not run based on solid data. So, if we could see more data established and more active discourse surrounding the topics, we should have more statistical data which we could use for empirical analysis. Then we would have a clearer idea of how fair use doctrine can be used and how that could contribute to the advancement of the cultural industry. If that progress could be achieved, and if we could have further research by researchers like Dr. Park, then I think we would have a more in-depth discussion on fair use. Thank you. Thank you.
때문에 제가 고민이 큽니다. 아주. 자, 이나래 작가님, 네, 부탁 좀 드리겠습니다. 조금 더.
Natalie, yes. It's your turn next. Please give it as short as possible. So I've been working as a scriptwriter for the last 19 years. I used to write for various different programs. And I am right now preparing a program writing a script for a program that's going to be introducing various civil servants around the country. And I'm collecting a lot of material in order to prepare for the program, and in the process of negotiating and processing the copyright, because I called up a news outlet, and it seems that just the royalty that I have to pay is huge, and they really differ. And it seems that the right holders, they are able to just say whatever price that comes into their head, and so the conclusion from my end is just just not going to use it. So it's not so much about fair use per se. Of course, we do have to get permission, and we do need to pay a royalty, and that is a norm. If you look at Disney Plus or the Netflix and other kind of overseas OTT, they very much limit the use. You can't use it at all. In the case of Squid Game, it's made by a Korean director, but the copyright is owned or dominated by Netflix. And even the script writers have participated in the original, but have no copyright. So OTTs like Netflix and Disney Plus are actually making the fair use defense meaningless, because they are reaping exorbitant profit, which is quite ironic. Also, when they use background music, they are using music, but they don't want to pay the royalty, so sometimes it's just make the music on their own, because they don't want to pay royalty to others, whereas they get huge amounts of royalty for themselves. And so when this kind of profiteering meets the fair use provision, I think it's leading to a lot of side effects. I'm not trying to say that we should not really be paying remuneration, but I'm just trying to say that there are so many differences. When there are photos and images on the internet, they can be very helpful in making of a program. And we are actually using those kind of works for other kind of procreations and productive means. And we are actually contributing to the further of the development of the culture and the arts by writing a script for a TV program. And in that sense, I think this kind of research about the quantifiable criteria is really innovative and very much necessary. As a creator myself, I am a writer, and I also receive royalty, and I receive a fee for my creative work. And I believe that exclusive rights should be guaranteed over the work that I write. And so I'm hoping that through this kind of conference we'll be able to come up with more details to this kind of quantifiable criteria. And there also has to be a monitoring system, as the doctor had mentioned. So then, how are we going to establish and operate that kind of monitoring system is another question that has to be analyzed very deeply into the researchers. There are writers and producers and the practitioners who would also like to contribute to that discussion. I think it's important for all the different types of stakeholders to participate in the debate, because it's only when the practitioners actually participate in the discussion can we make a certain system or policy useful in society. Okay, now the mic goes to Mr. Tae-young Kim from the Writers Association of Korea.
드리겠습니다.
Please, yes, conclude the discussion. I am Tae-young Kim, as introduced, from Writers Association of Korea, which is a group of the primary creators, including novelists and other creators. I feel like I'm the only person from the labor side of the discussion. The copyright of authors are sometimes seen to be the hindering factor of fair use. And I feel like that is the undertone of the discussion. So reducing the rights of the right holders and promoting fair use seems to be the keynote of most of the discussions. But the value of copyright itself is often seen as public good, and the right holders making claims are often looked down upon, and people question, isn't it good if your work is promoted? And there's the bookstore, Kyobo bookstore, and the readers can always just skim through the books without buying them, and this is ridiculous. Books are valuable information where if it's consumed once, then the value is reduced. But without negotiating with the creators or the authors, it's just provided as if it is a public good. And the copyright of public sector works is the same case, and the works in the library is not the entire picture. When it comes to children books, they are stories that are consumed at a certain age groups, and people don't hold on to them for the rest of their lives. So they're usually lent by parents for a few months, and then they're returned to the libraries. So the industry is almost disappearing. And the annual income of many of the authors are already pretty low, but if even a part of that income has to be sacrificed due to fair use, then they would be out of their jobs. In fact, all industries, when we look at the policies being made, they seek expanding fair use and reducing the rights of creators. When we looked at the EU AI Act for the advancement of the industries, they deem authors' rights as something that could be sacrificed, or else they would lag behind other countries. And this is the keynote that we see in many of the different industries. And for the textbooks, for up to high school students, the remuneration is exempted, and that was put in place in the 80s, but now Korea is an advanced country, but the provision still stands. So this is questionable. If such provisions are abused and the rights of the creators are reduced, then why would they continue to continue their creative activities? You have to keep this in mind. And the quantifiable judgment is very difficult, especially in broadcasting areas. But broadcast programs are conducted for a limited time, and we don't read out an entire novel or an entire poem. They only use portions of the literary works, and usually they do not account for 10% of the entire work. And Dr. Park said that 2 verses of the poem could be minimal enough, but still might need permission. But for another poem that is longer, then taking 2 verses from that longer poem would not make 10% of the work. So it would automatically fall under fair use. And in another work, there are 2 verses that are very famous and significant. And that poem is also long. So taking 2 verses of that would be fair use. And quoting sentences from novels are almost all of the time fair use, because novels are much longer. So just citing those works for 2 or 3 seconds in the broadcast are automatically almost all fair use. So I'm not saying that creators desire excessive remuneration, but But the derivative creators, well, we are seeing an ample amount of their work, like on YouTube. They make summary versions of films. Then, where is the revenue attributed to? The creators of the shorts of the films. In a very interesting video program, they play a very interesting job of making very interesting clips of films. But the revenue incurred from that derivative work does not attribute any revenue to the creators of the original film. So the author of the original work would not profit at all, while the authors of the derivative work reap all the benefits. But cases where Netflix are trying to produce titles, well, when they really need a content, they would respect the copyrights, but it is the marginalized creators who are bearing the brunt of this reality. So we will continue to see discussion of quantifiable criteria, but please remember and consider that the authors of the original work must also be able to profit from their work, and also consider the special characteristics of literary and artistic works. And you gave this example of taking one sentence out of a work, and the examples of the famous poems that I have cited, the verses could be generic sentences, but the sentences were also derived from a certain creative process. But just merely deeming that citation of that verse as fair use because it's just one sentence really does not pay respect to the creative process. So I'm sure this is a multi-stakeholder discussion that we're having, but please think about the perspective and position of the creators. Thank you.
제가 자불안석입니다.
Yeah, thank you very much for your contribution. So I think we don't have enough time to entertain any questions from the floor. Sorry, I know that we don't have time. Let me just take 1 minute. So, Dr. Park has, I think, contemplated deeply and come up with this idea of the quantifiable criteria. Then if you look at this equation, so you have P, and so the royalties are and cost is C. So if there is no litigation, then the C would be 0. Then it would become 0. Then that's fair use. So if I don't litigate, then does that mean everything is covered by fair use? And then, so I think the premise of this equation is that there is litigation. A few years ago, there was a particular service, and how many seconds of the use was the big issue here. And so there was a quantifiable criteria. In literary works, it will be how many words, etc. So, but that kind of contemplation, I think, is not really included. So I think this equation comes mainly from the litigation perspective. It doesn't really take into account the other factors that have to be also taken into account.
It is true that I looked at it from a litigation perspective and from the perspective of the producers or users who are willing to use the work. And to them, litigation cost and royalty are the two key factors. So that is why I came up with this formula. And the case where there is no litigation raised are cases where the works are already in public domain. So that means 100% fair use. So And I think C being 0 would represent those cases of using public domain, and P could be also 0, and C could be 0, for which copyright has already been expired. So the criteria is how much portion of the entire work corresponds to fair use. That is difficult to be quantified, so that was not included in this formula. To further refine this formula, other variables like what proportion of the entire work has been used should be added, but we don't have enough data for those variables, but that is what I intend to do in the future.
굉장히 논쟁적.
Yeah, it's an issue that we can debate on for a long period of time. So it's been more than 10 years since we've had this fair use provision, and still we don't have a judicial precedent. So that means that the fair use provision is not being applied, and we still have yet to see accumulation of more judicial precedents on the legal side. And also from the economics side, I think we need more analysis and research to be able to trigger more of an active debate, so that we can also have a detailed discussion about this kind of quantifiable criteria. So I'd like to thank all the participants, the presenters and the panelists for bearing with us until this time in the afternoon. Thank you very much.
네, 유익한 말씀
Thank you for your insightful comments and remarks. This closes the 2024 KIP Alai Literary and Artistic Works Copyright Conference. Today's conference clip will be uploaded on the KIIP YouTube channel. Based on the insights that you have provided, KIIP will continue to strive for the transparent settlement and distribution of the remuneration for literary and artistic works, and I thank all participants who bared with us until the very end, and please enjoy dinner. Thank you.